Good morning, everyone. This is Tim Wilkins from the Bracewell Environmental Strategies Group, and we're here to talk this morning about environmental management systems. This is not a super topical topic. There's no sort of giant sea change that happened in the last month that I think makes this an important topic. I think it's a box a lot of us felt at our individual companies were checked 15 or 20 years ago, but it's an evergreen topic that does merit revisiting. There are obviously changes that have taken place in environmental enforcement since environmental management systems sort of first came in vogue, and there are also some changes to the most recent version of the ISO standards. So I thought some people would be revisiting their environmental management systems, and if they weren't planning on revisiting them, maybe this would be a good opportunity to engage the conversation about whether that is something that's a good idea to do in the near future. So I'm going to talk about, there we go. Talk about environmental management systems, what they are, what their rationale is, what their elements are, the different options, some of the recent developments. We're going to talk, I think, the biggest part of our focus today is going to be the ways in which environmental management systems are legally loaded. If EMS is done wrong, or if it's not kept current, this is a living document, living process, how it can increase rather than reduce your legal exposures. And then we'll talk and conclude with some methods for managing and minimizing your EMS-related legal risks. So for folks who are not well-versed in environmental management systems, don't live in the ISO world, an environmental management system is really just a company's approach to managing its environmental issues, compliance, and performance. It's how your corporate EHS function is structured. Does environmental report to operations? Does it report to legal? Does it report directly to a CEO? In your organization, who's responsible for what? How do you implement the environmental function within a company? That's basically what we're talking about when we say EMS. An EMS commonly is a written document that documents the company's environmental policy. It can include procedures for identifying environmental concerns, for setting environmental goals, assigning roles and responsibilities, how companies check up on or assure compliance, whether that's audits or other systematic validation methods, how companies correct concerns that are identified. There are a lot of different models of EMS that are on display throughout the corporate world. Some companies are very structured, very formal. Everything's run through either electronic or paper procedural systems. Some companies are more or less centralized, with the EHS function taking place down at the plant level or up at the corporate level. Some EMSs are driven by external standards. They're European standards, ISO standards, responsible care for the chemical industry. Some are just built to suit what works for my company. So there are lots of different models, but all of them share this feature of creating or reducing legal exposure. I want to talk through sort of how that works. Starting with the ISO model that I've made reference to, I think this, for folks who aren't versed in EMS, I think walking through the elements built into the ISO 14000 model that's in effect today is helpful to understanding what we're talking about. ISO published a voluntary standard, the ISO 14001 standard, as part of the 14000 series back in 1996. The current version was updated in 2004. There's a more recent version, but the version being certified to for most folks these days is the 2004 version. The ISO model starts with an element that the top management of a company is going to institute a policy and a commitment on environmental issues. What's the corporate directive? What's the North Star for the company on environmental performance? Just lays out a broad framework in which the rest of this is going to happen. Second element is that the organization convenes people from throughout the organization to identify the important environmental aspects of its activities. How does our company, how does our facility relate to interact with the environment, inputs, outputs, ways in which we impact the environment. The company then develops measurable objectives and targets for environmental performance. You've certainly seen lots of folks looking at their carbon footprint and how are we going to measure our carbon footprint, how are we going to reduce our emissions, what's our sustainability look like, things like that, targets and objectives for environmental performance. The company develops plans and procedures with designated roles and responsibilities for individuals within the organization, what plant manager is responsible for, what the environmental manager is responsible for, what the VP level folks are responsible for, going through and identifying designated roles and responsibilities. ISO provides an element for regular and updated training to ensure employee competency on these issues. There's periodic auditing and monitoring to ensure the implementation and effectiveness, and systems for tracking corrective actions that pop out of that process or that otherwise surface. Document control and record keeping and retention standards. Finally, there's a regular management review on a periodic basis to identify where the management system isn't working well, and that's a feedback loop that goes back to the top of this process. Do we need to change our policy? Do we need to add new aspects? Do we need to change objectives and targets to update them, revise plans and procedures, and so on? The goal of this feedback loop is ultimately continuous improvement on environmental performance. So with this ISO model, some companies seek an independent periodic certification or recertification of the company's system's satisfaction of the ISO standards. I think more in the US, companies self-implement. ISO 14000 is common, but I wouldn't say it is what most companies are doing in the US. More have some system that's built around standards that look a little bit like this, but without the formal certification process. Formal EMS as a discipline really took off in the late 1990s, early 2000s in response to heightened demands from the SEC, the Sarbanes-Oxley legislation, and so forth. There were also certain industries, the automakers in particular, were insisting that any of their vendors, anybody supplying them parts or products or services or whatever, also be ISO certified. So there was a real stir about this in the sort of late 90s, early 2000s. But this ISO model, this EMS concept, again, I've mentioned responsible care that the chemical industry does internally. There are European standards out there. There are just a variety of EMS standards and opportunities that folks can look to. But with that, you sort of, I think, get the sense of what an EMS might look like. There is a new version of the ISO 14001 standard out, published in 2015, and designed with a 3-year transition period for people who are certifiers to get the EMS implemented and certified by September of 2018. So again, it's timely for folks to revisit if they're going to be certified to the ISO standard. If you're a non-certifier, you still need to be aware that what state-of-the-art for management systems in industry, what peer companies might be claimed to be doing in terms of an industry standard, that's getting an update. So even if you're not certifying to the ISO standard, the fact that there is an updated version is something to be aware of for the non-certifiers. I'm not going to get down the weeds of what's happening with 2015, but there are several entirely new elements and new documents. There's a focus on risks and opportunities. There's a section on context of the organization that didn't exist before. And there's an interested party, sort of a stakeholder concept that wasn't in the prior version of the standard. There are also significant changes to the aspect issue, objectives and plans, emergency preparedness and response, and a variety of these other issues. There are significant changes between the 2004 version and the 2015 version. So again, if you are an ISO certifier, even if you're not, it's worth looking into how things are changing in that respect to stay current with industry standards. So what are the potential benefits of EMS? I think probably obvious. By approaching environmental management systematically, the idea is that the company is going to thoroughly self-examine. It's going to prioritize among all of its issues and concerns, and that helps prevent issues, and the most important issues, from slipping through the cracks, going unnoticed. Properly implemented, an environmental management system ought to surface concerns that might otherwise be overlooked. This could be compliance issues. It could be performance issues that create legal risk. It could be performance issues that create reputational risk. Anyway, EMS is designed to surface potential problems, potential concerns, ways of doing things better from an environmental performance and compliance perspective. Theoretically, this strong EMS idea is good for public relations, government relations, and commercial relations. I think you're able to point to, I've got this great program in place, I've got this system in place that's designed to make sure that our environmental performance is strong. That has obviously a great potential benefit for you in all of those scenarios with all of those outside actors. Ideally, environmental management system also helps if things go wrong. If there's an incident, if there are violations and some sort of big enforcement action, if you're under the microscope for whatever reason, just your industry is in the media, right? Having a robust EMS helps if things go wrong. You can point to it and say, look, this incident, this non-compliance, whatever, that happened because accidents do happen, but it was despite our best efforts. We had this really strong program in place that was designed to prevent that. This was unpreventable. They're also built into Department of Justice policies, EPA policies, and other sort of enforcement-related principles that are out there, concepts about an effective compliance policy. Having an effective compliance policy in place can result in leniency, the choice not to bring enforcement in the first place, or if enforcement is brought, to have a more lenient penalty sought or assessed ultimately. So lots of potential benefits there for having a good EMS in place, but there are risks. So if you think for just a moment on any of the elements of an EMS, or on just a concept of a written internal corporate commitment to do stuff, that's obviously stuff that's legally loaded. Now, 3 overarching legal concepts I'd like you to consider. The first is when you have internal written policies, procedures, commitments, do those become legal duties? In other words, if you fall short of your own policy, have you violated something that a court or a jury or whoever might later find to have been a duty you undertook? Second concept is knowledge. Knowledge is a driver in criminal liability or enhanced civil culpability, so knowledge is an important concept, and EMS certainly brings that to the forefront. And then there's evidence. Privilege versus non, increased self-examination and documentation is just an inevitable part of an environmental management system. So what evidence might be created, might exist as a result of EMS. And of course, there's a risk. This isn't a downside, it's a failed upside, but you design this EMS and you don't hit the marks in, like, for example, the DOJ's policy on enforcement leniency for an effective compliance program. If you don't hit all of those marks, say the words the right way, are you maybe failing to get the benefit? But really, I want to focus on these 3 legal risks. So here we go, written commitments as a legal duty. How you might implement some of the EMS elements that we've discussed does create this concern. If you, for example, have a corporate policy that says we're going to put environmental protection first, nobody actually puts environmental protection first, or you just probably wouldn't operate. You wouldn't have emissions. You wouldn't generate wastes, right? It is an important consideration, but sort of phrasing it that way can be troubling. The I will do no harm to the environment concept, again, just isn't realistic. Some people create policies that are very aspirational and that can really put the company at greater legal risk. It's important to say that environmental performance and environmental protection are very important. We're going to strive to do this. We're going to resource it appropriately, but being careful about super aspirational policies that can get you in trouble at a later date. You can, in an EMS, commit to staff or resource particular issues that are identified through the aspects and planning process. That's something that you can spell out in writing. How you spell that out in writing, and whether it's conditional, whether there are exceptions to completing those are things that can, again, get you in trouble at a later date. The development of specific environmental objectives and tracked metrics. Those are things that if you say, I'm going to hit this target and you don't, could come back to haunt. Same thing with the commitment to training and competency. If it turns out you put somebody incompetent in a position, or they weren't adequately trained for the position, and something goes wrong, that's something that, again, you're going to have the opportunity to see on poster board in front of a jury. the commitment to auditing, monitoring, management review, if you don't do the things that you commit to, if you don't provide yourself enough flexibility, that can later become evidence of a legal duty. And I'm going to sort of explain why. I think I got the order backwards here. But if something goes wrong and you haven't lived up to your own written expectations on these issues, it becomes very hard to argue that, well, I didn't know about that, or I tried and fell short. It's hard to argue that your own policy that you set out in writing as your corporate objective, as your corporate commitment, it's really hard to argue that that wasn't a reasonable care, or a standard of reasonable care that would set the bar for a negligence action or otherwise. It evidences your awareness of concerns about this stuff, and if you don't follow through, that policy, that procedure is going to come back to haunt in subsequent proceedings on the thing that went wrong. Bottom line, if you talk the talk in an EMS, you have to walk the walk. I would ask everybody to think, if I've got an EMS, I've got it in place, is that a notebook that's just gathering dust, or are we living it every day? And that's something that's important to check into. All right, knowledge. Knowledge and culpability are obviously interrelated concepts in criminal and civil enforcement. Knowing violations of the law is a standard for many of the sort of higher level environmental crime statutes. And civil enforcement, culpability is always a factor in those agency penalty policies, right? Then separately, there's civil liability scenarios. Again, if you have an incident, an explosion, there's going to be tort litigation that comes out of that. The exemplary damages, gross negligence, intentional conduct, and the like, those are civil liability scenarios where what you knew and when you knew it is really an important piece of evidence. So if you can show knowledge of a violation, if you can show knowledge of a risk, and those weren't acted on, that's something that the EMS can make more available, can create new evidence of. It suggests basically the company is going to systematically know its business at all times, at all levels. And the EMS also creates a number of, sort of check the box, create the document, keep the record, prove I did what I did. That increases under a typical EMS to show sort of what the company knew, what people within the company knew, and when they knew it. Who knew what when is a capsule summary of the whole discipline of white-collar crime law, right? So knowledge is an important feature that is sort of problematized by EMS. It's much harder to say there wasn't evidence of knowledge when the whole EMS is built around this idea that you're going to know more and you're going to document what you know more frequently. And then evidence. As suggested, evidence of company duties and failures of those duties and evidence of knowledge can also emerge from EMS. There's also a great deal of extra evidence that could be relevant in certain proceedings that an EMS can generate. When a company sits down and decides what my environmental aspects are, that's an important exercise here. But if you miss an aspect that later leads to an incident, if you miss an aspect that later leads to an event, that could be evidence of the failure of imagination on something like this. If you do identify the aspect and don't act on it, that can also be evidence. Basically, there's going to be second guessing, did you get it right on the aspect process as a piece of evidence in a proceeding like this. What were the company's plans to address a particular issue? And did those planned steps happen? What do the company's environmental metrics look like? You can't manage what you can't measure, right? But once you've measured it, it can be used as a club against you. It can be used to second guess how you did the measurement. It can be used to second guess whether you prioritized correctly. What the company's self-audits and management review revealed. This is a topic that I've talked on many times. The whole idea of audits is basically drafting a confession of all the areas in which you've done wrong And that is obviously potentially dangerous evidence. Management review, same thing. What were our systematic failures? Let's write those down. Those are clearly important issues and could be important evidence in some proceeding if something goes wrong. And again, the concept of EMS is all of this stuff should probably be better documented than it would be under a non-EMS setting. So basically what I'm suggesting is this leads you to think, number one, when and whether should we document particular issues? And that's something to think through sort of top to bottom. And then secondly, under what circumstances can you and should you invoke attorney-client privilege, attorney work product doctrine, audit privileges, other available privileges. And all of this, I think, merits a very careful think. It probably got a careful think when you originally developed your EMS, but it also merits a periodic rethink because, again, the landscape has changed. The regulatory landscape has changed, the enforcement landscape has changed, and how stuff can be relevant has changed. So I think it would be worth thinking through your EMS and on those 3 points, the concept of evidence, the concept of knowledge, and the concept of the written commitments that you're making in the EMS. I think revisiting all of those 3 sort of big legal issues is worthwhile. So how can we limit the risks? A robust EMS can be a very healthy way of tightening up a company's internal approach to its environmental issues. It's this systematic approach to find and address potential gaps, to improve the way in which you're responding to environmental compliance issues, to enhance environmental performance. That's very healthy. And if and when things go wrong, having these systems in place, having thought it through ahead of time, can help you react and better defend yourself. This idea that, again, whatever went wrong happened despite best efforts. We have this robust program. We have all this information. We've got this system in place to prevent stuff and to react if stuff goes wrong. Having that in place really is healthy, really is advisable. But there are just many elements of doing this that when you sit down with them and marinate in them a little while, you realize that they really are legally loaded. So recommendations here, things that companies should do if they're building an EMS for the first time, if they are rethinking or updating to the 2015 standard or otherwise. I would say, first off, have your EMS documents, the whole system top to bottom, carefully reviewed by counsel for unnecessarily risky language, improper ways of saying things that undertake a duty, a legal duty, stuff that's confessional on who knows what when. When in an EMS and deciding roles and responsibilities, you spell out that somebody is, the designated felon, as it were. This is the person that always knows this. That can be really troubling evidence at some future day. So spot for gaps, spot for risky language, spot for those kinds of concerns. Counsel are professional paranoids, right? We live in an enforcement world. We see how facts and evidence are used against companies. It's our job to think about how stuff can go wrong, and if it were to go wrong, how this stuff could be used as evidence against you. And so that's a very important thing, having counsel review that. I would separately look at sort of the updated list of leniency opportunities that are out there, whether those are audit policies, whether those are effective compliance program language in the DOJ guidance, whether it's penalty policies. I'd look at those various leniency opportunities that are out there in the event that something does go wrong, in the event there's a violation. Figure out how to maximize your management system's fit with those policies. If there's language that those policies are using, that's important to make sure that your EMS also points to that language, uses similar language, so that it's very easy to, in an enforcement scenario, very easy to show the government that you were meeting those standards. You should audit your system's performance, not just audit your compliance, but audit your performance under the system to ensure that the company is walking the walk on your EMS commitments. And if you're not, again, a lot of people built these notebooks in 1999, and they've been sitting there since, right? make sure that you're walking the walk. And if you're not, that doesn't mean, you have to change everything about your company. It doesn't mean that you need to scrap the book entirely. You can adjust to drop the stuff that you don't need and don't do. It gives you an opportunity to restart stuff that you should be doing that you once committed to do but you haven't been doing, or to modify the system to be more modern and to fit the circumstances of the organization. Last but not least, you should work through the EMS and the types of documents that are being created through the EMS, and consider the circumstances where you want to use attorney-client communications privilege or other relevant privileges. Audits are obviously a great example where you're creating confessional stuff of any kind. Do you need to apply privilege? Is privilege important to figure out how to get it applicable in those circumstances? So bottom line, this is about striking the right balance between risk and reward. Environmental management systems can be really a powerful tool for improving environmental compliance, for improving environmental performance. But again, there are so many ways in which the EMS can create new and larger risk for a company. So it's a matter of careful review, careful thinking, the application of a good legal editing pen to reel back the stuff that's more dangerous than not, and to identify areas where there's going to be some danger that's built into this EMS. How do we help it not become evidence by applying privilege? So as always, we'd be thrilled to help anybody work through those issues, to review the EMS, to talk this through in a more specific context specific to your company or your EMS. But the bottom line is there is a moment now with the 2015 standard coming along, being applicable in 2018, where I think folks should be revisiting whether they're living up to their management systems, whether their management systems need an update to meet the industry standard, and again, to identify ways of mitigating those risks with some careful editing, some careful oversight of how you're implementing the EMS, and again, the application of privilege. Thanks everybody for taking the time. Chris, are there any questions? If anybody has questions, you can type those into the box. We're on for, I think, one more minute here. All right, well, listen, thanks everybody. Appreciate everybody's time, and we'll be sending around a note after with links to the presentation and the slides. If anybody would like to talk through any of this, just let us know. I look forward to talking with you again. Thanks.